Thank you. It is very imposing to find ourselves here alone after the talks that we've heard. Thanks to Rosa, Antonio, to the different teams. It is a great pleasure to be back here, especially in this wonderful new environment in my city. I don't want to waste any time because the topic I will share with you, I know that in such a technical forum as this, talking about legal aspects is sometimes somehow hard. And at the end of the day, we're talking about cybersecurity incidents, and I think it's important to take into account that one of the main consequences of such incidents when we talk about cybersecurity is liability. Liabilities from different areas. What are we not going to talk about? Just to put you in the picture. Well, we've talked a lot in past editions about things related to cyber crimes and also some regulatory aspects, regulatory files as a consequence of cyber attacks. This is not what we're going to be talking about in the next minutes. We are going to talk about the growing trend of claiming liabilities. As we heard in the previous panel, there are certain consequences that must be taken into account by the companies, because the problem is that when a company, apart from being a victim of a cyber attack, they might need to face different liabilities, not only of a regulatory nature, in a form of a sanction or a penalty because of a breach of security, but also some civil liabilities. Because in that breach led to the non-compliance with certain contracts. We live in a world where the digital transformation of companies cannot be stopped. And it is not only the risks of those technological companies, but rather any companies that provide services through new ways of communications, through digital services. When they have a breach in cybersecurity, they might be violating their own or breaching their own contracts. And what's even worse, after you are the victim of a cyber attack, you may find yourself being liable in the civil world, in the ordinary world, for damages to third parties, and you might have a claim for liability. This is what we're going to be talking about. We will talk about the trends around the world, where they come from when it comes to claims due to cyber attacks for the businesses themselves. Normally, it is often said that lawyers create problems so that they can later solve them. And whether you like it or not, this is very much the case. In the European world, we are not talking about the US, we all know how it works, even if it's only because of the films with the different class actions, etc., which seem a little bit far away for us. We can talk, however, about things that might seem far, but which is nearer and nearer. And it is now part of our environment. So what are the signals that are telling us that this is coming? Well, regulation, the European regulation on data protection was a milestone. It is a direct application regulation with a very important rule, which is that those in charge of the treatment of data may be responsible and liable for damages, be material or immaterial. And let me just emphasize this, because so far in the Spanish legal system, this is not the American or Anglo-Saxon legal system, we were very much centered around the material damages. However, this is the first norm, and again, direct application. It talks about not only material damages, but also non-material damages, with all the difficulty when it comes to assessing and evaluating the actual damage. But we have that possibility. Secondly, we have the ruling from the European Council, the direction for the so-called collective redress in terms of compensation. And this is interesting because of two reasons. First, because it binds the states to establish the necessary efficient mechanisms in order to regulate mass claims. Although theoretically the states have incipient models for mass claims, these are not really usable. They also open the possibility of the users to go for mass claims. And then the second possibility, this is a directive, it's part of the European law. This, what it means is that you can file a claim in a specific European country so that the result of that process may affect all consumers that are in an identical situation throughout the European Union. So even if a country is lagging behind in the development of that new claim for damages, at the end of the day, after security breaches, we are talking that there are no borders, no territories. For a company that has had a security breach elsewhere, and for those businesses to be liable not only their countries but in the whole market where they operate. And obviously the NIS directive and the transposition or adaptation to our own legal system due to the Decree Law 12/2018 and also 43/2021, which imposes certain obligations. And if these obligations are not complied with, then the breach will be accompanied by a breach of the norms that must be complied with. And what is the last point? Well, the growing world of cyber risks, insuring risks, and when someone thinks about insuring the potential civil liability coming or deriving from cyber attacks, this is what we find the third-party founding in the current world. Litigation funds, something which is all the rage right now, which are moving now more than $12 billion. These are funds that basically what they do is they buy claims, and this is being developed. And I heard only last week in the news that the target of these funds are those cases derived from cybersecurity breaches and deriving from climate change. Climate change is something that might seem a little bit further apart, but cybersecurity breaches is a reality, and they will start buying mass claims in order to initiate these processes on the basis of cyber attacks. I now work for a British law firm. That's why I bring some British cases from the UK. But at the end of the day, the trend of the transposition to European law, which is no longer the British law, this will come due to the cases that are being heard in the UK, which are a lot more developed than ours. There is an interesting case which is being debated at the High Court of the UK, which, although it does not directly come from a security breach, everybody understands that when the ruling from the High Court will come out, everybody will know how the claims liability claim will come about. This is somebody called Lloyd. When Google had a problem with Safari, there was a privacy policy, there was a problem related to this policy. This caused very many problems to Google. They had to pay a big fine in the US, and this came all over to the other side of the ocean. And there is someone called Lloyd who claimed against Google on behalf of all the users, iPhone users, with that problem. And he put together a claim on its own right, representing 4 million people affected, and if this goes ahead, Google may have to pay £3 billion. And this is based on two very new things, which might not be that strange in American law, but what we will see on this side of the Atlantic is what will set the difference. First, if one single person can represent an indefinite number of users, as long as they are in the same position, this is the opt-out system. So I launch an action, and except if the user or the person affected voluntarily wants to walk out of that resolution, they will be part of it. And this, what it entails at the end of the day, is that not only through associations of consumers, we might have rulings with an effect on all people affected, just following one single case. And then secondly, because we have the non-pecuniary damage system. Can we establish a damage system where you can set 50, 60 or 80 pounds per user without having to demonstrate that you indeed suffered that claim on those damages? And this is the debate. It is important because what you can see regarding the opt-out system is what the directive has set out and has obliged the system to establish opt-out systems for mass claims from users. And I also read that Google has a second claim in the UK deriving from the deep mining because of the way they managed health-related data in the UK. There is another claim that has just been filed against Google on those grounds. Other examples, Marriott. Marriott is having to face a civil claim on civil damages, also in the UK, which is also very remarkable. And some of the cases, this is related to a cybersecurity breach. This is a very recent case. This is from the High Court in the UK. And this is a cyber attack claim, and these are the two aspects that are being assessed by the court. The analysis for the case, for the resolution, is the positive conduct, the regime of the pecuniary damages, and the obligations. What is going on in Spain? Well, in Spain, this type of claims derived from cybersecurity breaches have already started. So a famous one was the one filed by the Organization of Users and in Spain against Google, which did not progress, but this is telling us that this is a reality. We have collective or mass claims in Europe, and this is the future. And as I said earlier, there are two types of liability that a company may have to assume in a case of cybersecurity breach. Obviously, contract base. If I am providing a contracted service and there are a number of damages, I will be breaching the contracts. I might be suffering delays, damages, orders, etc. Everything that you can think of in the world of contracts, anything that will be interrupted, the breach of service level agreements and what have you, and particularly the liability due to a defective product. And I talked about how the great software producers get away with it, and this is what happens normally, because we understand that those new threats are still very much unpredictable, which makes them not to be considered a defective product. But if this is only limited to a specific kind of threat and does not go beyond all the different other type of manufacturers, then that's good enough. And then we have the responsibility or liability for damages not related to contracts, such as, for example, the Data Protection Act that we saw earlier. We have the cases of financial institutions, which indeed, through the Payment Means Protection Directive, there is a protection in cases of phishing, for instance, in such cases when the person affected acted with negligence, etc. But here, our legal system gives or passes the liability to the financial institutions. And then the last example I have for you, a very recent one, the Barcelona court, regional court, has emitted a ruling for a company against a company called Privalia, which was claimed due to a CEO fraud, and then they won the case. So cybersecurity incidents and liabilities has to be distributed. In this case, it fell on the actual financial institution. We must not forget that we must have an adequate compliance policy, also complying with the regulations and the obligations. We need to comply with these regulations. We have to implement compliance rules, etc. Obviously, we need to insure the risks. Not all businesses need to insure. So if you're not going to drive, you will not need a car insurance. But if I do provide this type of services and I am aware that these incidents may be part of my business, we need to insure those risks. And finally, let's not forget that risk management, when somebody has a cybersecurity incident, we are going to be thinking about the technical side of the incident, the explanation, the everything related to the actual fact. But let's not forget the legal aspect. There is a part that's related to legal management, which is really important. So don't forget to consult your lawyer. And well, I think in a nutshell, that's what I wanted to share. And that's all from me. Thank you, Fernando. Let's have a round of applause for him.